Hi, good afternoon, and welcome to another International Trade Association of Greater Chicago program. And today we're going to be talking about how to hire and retain top U.S. talent, specifically if you're a foreign-owned U.S. subsidiary or a newer company. And we're going to be talking about setting up an office, building out an office from a managerial standpoint, and also from a legal standpoint, and what things you want to think about from a strategy perspective, because in this day and age, it's really difficult to find top quality talent and then to retain that top quality talent. And so we're going to kind of go over some of the bits and pieces that we've all learned here over the years doing this kind of thing. And so I'll just kick off the introduction. So I'm Zach Pearson. So I'm the Chief Project Manager with Borderless Business Solutions. And so for the last 20 years, I've worked with international companies. I started out doing more import-export stuff out of the United States, selling globally. But in the last 10 years or so, I've really been focusing on helping foreign companies either set up their U.S. subsidiaries or turn them around if things aren't going quite right, or ramping them up if you've kind of hit kind of a plateau and you're looking to break through that level. And a lot of things just come down to the people, processes, and planning, and then the people, processes, and planning that specifically pertain to multinational companies where you have language issues and cultural issues, and then overcoming a lot of that. And so I've had the opportunity today to talk with Nathan Cutler. He's with Trelawny Associates on the labor law side. I'll let him give his introduction, and then we'll kick it off.
Thanks, Zach. Thanks for having me with you. Good to be here. So I'm Nathan Cutler. I work with a boutique law firm located in downtown Chicago. We really specialize in helping foreign companies expand to the U.S. and help them mitigate their risk in doing so. We're essentially a one-stop shop for all business legal needs, but a major component of that is employment law, and it's a principal part of my practice. So I've been practicing for 18 years now. I guess I'm dating myself, but 18 years now, and I really counsel my clients from every step in the employment process, from really the hiring of the employee through management of the employee and their employment with the company to termination or separation, and even post-termination or separation if there are claims made by the employee against the employer for whatever reason, or by the employer against the employee for, for example, breach of a non-compete or non-solicitation. I draft employment agreements, independent contractor agreements, offer letters, termination letters, separation and release agreements, and more. So that's a little bit background for me.
Great. So I think what I could do is I'll set the scene, and where the whole point is, so say, for example, we're starting a new company or a new subsidiary, and so you're in the process of hiring people and then putting together the systems in place to attract and then keep these high quality individuals. And what I found is that especially now, it used to be that where you just put together a job description, you put it out there and you interview the people. Can you do the job? Yes or no? And do they fit with the culture? Yes or no? And then you're kind of off to the races. But the tides have changed, and now employees are interviewing the employers in a lot of ways. And to really attract the best talent, you have to really focus on being able to demonstrate that you have good management practices, that you have the right tools in place so that when this person does come on, that they can succeed in doing what they're doing. So for example, CRM systems, really functional ERP or order processing systems, and other sales and marketing support, so that they'll have the tools they need to get out. And if it's a sales position, marketing position, to go out and make that business, or if it's a customer support side, that they'll have the systems that they need to provide the best customer service to the customer. And if it's on the finance side, do they have the right software that they need that functions in the US market, as well as be able to interface with the foreign company in a meaningful way that doesn't cause too many problems, and that there's a lot of thoughts that's been put into that. And then that's just the baseline now, essentially. And so now it's not just having the right tools, it's because when people start a new job, I mean, they're starting to pay attention. They're doing they have their checklist of things they're looking at to say that to feel and to see and that to demonstrate that they're working for a good company. And a number of those things are a good employment contract that makes sense, that's fair for both sides, that's legally enforceable in the United States or in multiple states. And then also, it's kind of strange, but a company handbook. I mean, for years, I started in big corporate, and we had the company handbook. We read through it, and our eyes would glaze over, and we sign it and move on. But really, after having been through this a couple of times, the company handbook becomes the contract with the employee on a much more a deeper level. And so having that in place is really important. And then once you have all of the contractual infrastructure in place, really good, really well put together pieces in that regard, the next part of it is how does this position help this individual grow professionally, personally, and how will they be able to come into work and feel good about what they're doing? They feel like there's a really strong sense of purpose, and that you're working with people, because typically we're as human beings, we're designed to work together. We're designed to work in a tribe, and creating a culture where people are work well together. There's infrastructure to help people work together, and then also the keen-eyed employees out there will look at, okay, does the management structure, do they have the ability to sit people down and help with conflict resolution? Because it's only a matter of time until, disagreements happen, and people have issues with this, that, or the other. And if you can sit people down and really help understand both sides of the equation and work people through those challenges, having the interpersonal skills to be able to do that, and the experience and temperament to do that, you can work people through the difficult problems. Because a lot of times really good people, they'll eventually come into a conflict of some kind. If you're not able to tamp down those issues, it'll blow out of proportion and people just end up walking away. They have lots of problems, and it's not if, it's when. And so having the management team in place that's able to work with people in that regard, but also if it's an international company, able to deal with the language issues, the cultural issues, and understand where both sides are coming from, and work through a lot of that kind of thing. And then from another perspective, now the people that you hire at the beginning of an office or a company aren't necessarily the people that are going to be the best suited for that position later on down the line. Because when you're building something, and you have to be, there's a different skill set for it's more of in a startup mode. And then as things evolve and systems become much more stabilized and regimented, then it takes sometimes a different personality. And people will either, if they can adapt to those positions, and sometimes people adapt out of those positions, and people come and they go as the company changes. So you have to strategically put your books in order, make sure your contacts are in place, but also making sure that the job descriptions there's a little bit of overlap, because the last thing you want to have is where you have a single point of failure. So an individual who has control over a huge part of the business, where if they suddenly disappear, get hit by a bus, or whatever happens, the company it'll be difficult, but it won't be groundbreaking. It won't break the company. And so just being strategic from a management standpoint, so that you help people either cross-train with that individual, so that if, say, for example, they need to go on vacation or something like that, or someone gets sick, whatever, you can cover people's desks. And that's one way of approaching it. But really having that be set up from the beginning, where cross-training and mitigating those types of managerial risks is just kind of built into the cake from the beginning. And with that, setting that scene, what I want to do is then hand it over to Nathan, and talking about setting yourself up legally, so that when people come and go, or there's sometimes where companies need to part ways with an employee where it's not totally happy hunky-dory, and therefore you have to have your contracts in place to really weather that storm, but be ready ahead of time, so that you're being proactive. So when it happens, you're just like, okay, flip the switch. Okay, we're ready. Let's just do this and get it done. And it's not a big deal. It's difficult, but you've got the tools to get through it and move on with life and business. So with that, I'll hand it over to Nathan and let him talk about the legal side.
Thanks, Zach. So I think I'll try to do this chronologically, and I think the first place to start is understanding where you're going to have your employee or employees. If you have a U.S. subsidiary, then the employee would be ideally employed with the U.S. subsidiary. It would not be the employee would not be employed through the foreign parent company. Employing someone through the foreign parent company subjects the foreign parent company to employment liability in the U.S. So one of the biggest pieces of advice that we have for our foreign clients is a way to separate legal liability in the U.S. From that of the location of the foreign parent company is to set up a U.S. subsidiary. So then, in order to separate that legal liability, the way to approach it is to run everything possible through the U.S. subsidiary, and that means, among other things, employing employees through the U.S. subsidiary. So once you determine where you might have a physical office or at least an employee located, then you need to qualify to do business in that state. Your U.S. subsidiary needs to qualify to do business in that state. So qualify to do business in that state by filing certain forms that we often help our clients with, and then making sure that you have the right contract in place. Before you can determine whether or not you have the right contract in place or what contract to use, you have to figure out if this person is an employee or an independent contractor. That issue is a really hot issue for many reasons, but one of them being the battle in California between Uber and Lyft and the California government and courts on how to classify those Uber and Lyft people, the drivers, whether they're employees or independent contractors. And really administrations and governments are trying to minimize the use of people as independent contractors, so which allows the companies to avoid having to get workers' comp, avoid having to pay into Social Security, avoid having to pay them benefits, and things like that. So obviously, there's a big interest from companies to categorize as many people as possible as independent contractors, but it doesn't matter what you label a contract. It can be labeled anything you want. That doesn't mean that's what it is. So you could have an employment agreement as your label, your heading on that contract. That doesn't mean that person's an employee, and vice versa. If you have independent contractor agreement, that doesn't mean that person's an independent contractor. So there are a series of factors, and they vary from state to state, but generally, they're fairly similar from state to state. And I just want to touch on those now so you have an idea of how to determine what this person might be, an employee versus an independent contractor. So I'm sorry, I had something pop up on my screen. There we go. So some of those factors are, does this person control their own hours of work and when they perform the work? Does this person control how they perform the work? Does the person use their own equipment and property when performing the work, like an office computer, phone, car, etc.? Does the person get reimbursed for expenses? Does the person generally provide the same type of services as the company who engaged the person? Does the person invoice for the work? Does the person perform the work through a legal entity like an Inc. or an LLC, or do they perform the services through just themselves individually? And finally, does the company who engaged this person, does that company withhold any any taxes from payments to the person? So really going through those factors when you retain somebody will kind of head you in the right direction of determining what that person is, an employee versus an independent contractor. I can tell you that if the person controls their own hours of work and if they control how they perform the work, then both of those things indicate independent contractor. But those two factors really are where my clients get hung up the most, right? Because a lot of times my client can control a lot of these things, right? Like my client can control whether it, withholds taxes from payments to the person, can control whether the person invoices my client for the work, can even, control whether the person performs the services through a legal entity. They can ask the person to form a legal entity at the start of the relationship. So a lot of those things, are things that my client can, in essence, control, and my clients don't have an issue with. But my clients don't like to, and companies in general don't like to relinquish, power to this person to, determine when they want to work, what hours they want to work, what days they want to work, and how they perform the work without really any oversight. And I think a good example of that is, my office in downtown Chicago. A classic independent contractor is an interior designer who would come to my office to perform interior design work. I don't control how that person does their work or when they do it. That's entirely up to them. I have no design bone in my body, so I even if I wanted to, I couldn't control when they perform the work or how they perform the work. So that's kind of a classic independent contractor. On the other hand, a classic employee would be if I hired an attorney and they performed, let's say, business immigration services, right? Because I didn't have an attorney that did that sort of work. And I wanted to categorize them as an independent contractor. Well, that person is probably going to be subject to my oversight, right? I like to provide legal services the way I like to provide them. And so I'm going to dictate, when they work and how they perform their work. And the services that they're providing are the exact same services that my law firm provides, right? It's not interior designer versus legal services. It's legal services and legal services. So that person would be more like an employee. And I don't want to belabor the point, but it is a very important one because of the scrutiny it's getting now, and because I have actually had a client that was involved in litigation for this particular issue, and it was the longest piece of litigation I've ever dealt with. It was 5.5 years before a settlement was finally reached on the brink of trial. So, and primarily that lawsuit had to do with this one issue of categorization of one person as an employee versus independent contractor. So it's definitely something that is important, not only because of that liability, from the employee who asserts, they should have been categorized as one versus the other, but the governments, if you're a company and you're miscategorizing your employees as independent contractors, then you're subjecting your company to a slew of fines and penalties for failure to withhold taxes, pay into Social Security, get workers' comp, provide benefits, provide, their family medical leave under the federal and state laws. It's like Pandora's box of legal risk, legal liability. So it's definitely a big issue. So once you, having said all that, once you make that determination of what the person is, legally speaking, then you can put the right written contract in place. And I highly suggest having a written contract. I always tell my clients, without a written contract, if there's a dispute, then really it comes down to who the judge, if there's litigation, as there often is, who wins that case comes down to who the judge feels is more credible, right? And you could have an employee that looks and sounds very credible, so you don't want to have it left in the judge's hand to have to make that determination based on that thing only. So have a written contract, an employment agreement, for example, and all of the material terms of the employment would be set forth in that employment agreement. So it would list, full-time or part-time employee, what they're paid as a base salary, when they're paid it, what bonuses or commissions are they entitled to? Are they entitled to health care and other, type of health benefits? How is it terminated? Are they an at-will employee, or are they being employed for a specific time period? An at-will employee. I'm sorry, Zach, were you gonna?
Yeah, I guess this is a great segue. And one point that just came to my mind is yet companies that are coming here from Europe or from Australia or from Canada, where employment agreements are a lot more onerous than here. It's much more difficult to terminate employees or just to change employment contracts in general. And so they tend to be very, very gun shy about bringing on employees. And they've had that really built into them from the beginning because of where they come from. And you mentioned the word at will and W-2, and and I think that some of the hesitation, whether they want to go with the 1099, is that they think W-2 is going to be like a European type W-2 agreement. And whereas it's not, you still have the at-will component there, and you can still hire and fire as you need to within reason, as long as you've got your really good legal framework in place. And so I guess if we could comment on that a little bit, that'd be great.
Yeah, so thanks for that, Zach. So at-will employment, I think, is a presumption in all 50 states in the United States. And I think it is quite a bit different way of employing somebody versus employment laws, generally speaking, in foreign countries, where the relationship is more secure in terms of their employment, and it may be more difficult to terminate that person. At will, you can terminate the person, or either party, really, the employee or the employer can terminate that relationship for any reason, any non-discriminatory, non-illegal reason, or no reason at all. And that's the core definition of at-will employment. And like I said, I think it's a presumption in all 50 states that employment is at will, unless there's something that suggests otherwise, right? And that's something that would suggest otherwise could be something orally said from one person to another, right? The employer, someone with the employer saying something that the employee misconstrues as the employer promising to employ them for a specific period of time, for a year, no matter what. Or it can be in writing. The other benefit of having an employment agreement is that everything's in writing, and there's what's called an integration provision in employment agreements that clearly explicitly states that that's the only agreement between the parties relating to its subject matter. There is no other agreement. There's no oral statements that are construed as a contract, or any other writing construed as a contract. What's on paper on that employment agreement is it. So an employee can't come back and say, well, I was promised by the so-and-so with the company, the employer, that I'd be, I would be employed for a year, no matter what, because that's not what's in the employment agreement. The employment agreement will state that very clearly and explicitly that it's an at-will employment agreement. So that's kind of a breakdown of the at-will employment in the United States. Does that kind of address what you were?
Exactly, and this actually does a real good job of teeing up the next subject line, which is going to be tools and tricks for foreign companies, or any company for that matter. Where do people turn when they're trying to set this up correctly from the beginning? And so I can kick it off just talking about, from my perspective, what I've used in the past, working with U.S. subsidiaries here, and we've used payment processing third parties. So you have the ADPs and the Paychex and a whole slew of other ones that are out there, and they all do a really good job with the payroll component. But one thing to keep in mind when you're looking at a lot of the third party payment processors is the question is do they have a section or services that they offer that have an HR component, and HR, including the legal aspects of the human resource component of employment contracts, that kind of stuff, just to kind of give you additional stories. So a little while ago, we had an issue with an employee who there was some disciplinary issues and just some other things that were going on, and it just started to really get a little bit out of control, and it got into some weeds that I've never been in before. And I was working with a third party payment processing company, and then they also had an HR person on staff who I was able to talk to and who walked me through a lot of the nitty gritty weeds, the issues that we had. And it was absolutely critical that I had that kind of legal guidance through that process, because you never know what you're going to get hit with. Even if you've been around the block a billion times or not, you're going to eventually something's going to catch you off guard. And especially when you're dealing with reasonable accommodation or other types of, just take a pick of whatever challenging HR issue, if you have to do it right the first time. And if you don't get it right when you're managing it real time, it really sets yourself up for some bigger issues later on down the line if you can't just wrap it up in a bow as much as you can and then move on with life and business. And so I guess, or there's that, and then also dealing with the Nathan Cutlers and the Torelli Associates of the world. There's a lot of people like that out there. So I guess, Nathan, if you could talk about your perspective of engaging with a third party, a legal, a law firm, or a third party payment processing company. Oop, you're on mute there.
So I think it's important, and not just for employment, really from as early as possible to engage an attorney in the US. And I think that's a fundamental difference between how attorneys are used in most foreign countries and how they're used in the United States. Attorneys, I think, are generally used in foreign countries to clean up a mess, right? Whereas here, it's much more ideal to retain and more common for a company to retain an attorney from day one, to consult with the attorney and setting up the company and checking all the boxes, legally speaking. So I think it's imperative to do that just generally, but also with employment, so that you can start off on the right foot. It's going to be much more expensive for a company to retain me to clean up the mess, right? Because I have clients do that, and frankly, it makes more money for me. I mean, but I can't, I can't counsel my clients to do that, even though it benefits me. I mean, it's can be very expensive. Really, the best practice for most cost-efficient practice for companies is engage an attorney early. Start off on the right foot, have the right agreements in place, because that really minimizes the legal liability when there's a dispute with an employee or independent contractor down the road, because you've got the right contract in place that protects yourself as much as possible. So and when as many of my clients do, when there is some issue that's raised during employment, for example, like an employee is sick, or they have a disability and they ask for what's called a reasonable accommodation under the ADA, one of the acts that protects people who are sick or who are disabled that can't perform an essential function of the job. Having an attorney or someone to walk through the legal issues with and how to handle that request is really imperative to limiting liability. So I think in some engage someone early and really lean on them throughout the process for consulting about whatever the issue might be.
And then from a management standpoint, and having all this in order, and then putting the hat on of where there's a employment situation where you're managing somebody out of the company for whatever reason, and if in the event that things do become a little bit uncomfortable or contentious or less than amicable, as what happens sometimes, it's just we're dealing with humans. That's just how it is. And So that my experience has been the best way to decrease issues is by being able to show that you have all the contracts in place, show that here are the rules that dictate this ending of this business relationship, whatever you're ending or managing out. And we are in adherence with all these components, and be very clear about how we're in compliance, very clear about how we have everything really well organized, and also that if at all possible, if it makes sense, to come up with some kind of an amiable an arrangement to help that individual walk away from the company feeling like they've gotten something out of it, like they both end the relationship on a positive note. And I guess Nathan, if you want to talk a little bit about that, and from your perspective, how to set that up and how to execute that type of a process from a legal standpoint.
Well, I'm to remind myself to talk about it. I'm going to talk about a separation and release agreement in a minute. But before I get there, I think it's to touch on something that Zach said. I think it's really important to have a written record, right? And although the employment agreement is the only contract between the parties, it's really ideal for the employer to put everything in writing and have an a personnel or employee file for this person. If the person, for example, is not performing up to what the employer's expectations were, or not meeting their obligations under their performance obligations under the employment agreement, there's ideally there would be some written record of that, right? That there would be a personnel file, there would be meetings that had happened, follow-up correspondence that lists the issues and what was discussed. The issue you're trying to avoid is when, let's say, the employee is not working out and there's a separation. Well, it makes it much more difficult for the employee to come back later and say, well, I was terminated because of this or that discriminatory reason, or because I have a disability and the employer didn't provide me a reasonable accommodation, right? Because if there's no written record of any sort of performance issues, and the employer wants to rely on, as a defense to those types of claims that there were performance issues, well, there's nowhere to look, right? I mean, where's the employer going to look for evidence that there were performance issues? Nowhere. So I really suggest throughout the process of employment that there be written records, and then if in the event of termination or separation of the employer-employee relationship, many times if my client is worried about the employee coming back and making a claim about something, or just the fact that the employee might be disgruntled because because they were terminated from their employment, then it often makes sense in those situations to have or to offer the employee a written separation and release agreement, is what it's called. And that's really, in essence, what that is an offer of a sum of money. Usually it's from the employer. Usually it's put in the context of 1, 2, 3, 4, 5, 6 months of base salary for the employee in return for the employee releasing any and all claims they might have against the employer. And that, kind of helps the parties separate amicably. The employee has some cushion to, before they find their next employment, and the employer has the peace of mind that there's going to be no lawsuit from the employee. So in those situations, a written separation and release agreement is what I would recommend.
And I think in that situation, and it's important to note for the international companies where that's not mandatory. A lot of the countries in the world having some kind of a separation compensation is part of the process, whereas here it's opt-in. And it really, it's reserved for the situations where you're trying to head off a challenge at the pass and trying to get ahead of potential issues. If it's just an amicable separation, just it's not working out and it's not really a big deal, then you just do the best you can to maintain a relationship and just say goodbye and beyond with things. But if when things are contentious and you really see this individual being more problematic later on, it's better to do what you're talking about, the separation agreement, ahead of time. But that's just left up to the judgment of the management in place.
Thanks, Zach. One more thing I want to add is it's important to engage an attorney to probably draft the separation and release agreement, but at least to counsel you on it, because every state has very state-specific laws about when these types of agreements are enforceable and when they are not, and they differ depending on the age. In many cases, the age of the employee. If the employee is 40 years old or older, there are special provisions that have to be in there or it's not enforceable. If they're under 40, then it's maybe a little less onerous of a separation and release agreement to draft. But nevertheless, there are a lot of steps that you need to follow in order to have this document be enforceable. What you don't want is to have an unenforceable document and you have paid thousands of dollars to the employee, and now the employee is free to make their claims against the employer. That defeats the whole purpose of the agreement. So
exactly,
just wanted to add that.
That's awesome. And it's really, and above all, it's if at all possible, getting back to the conflict resolution, it's the more management is able to sit down and talk to people on a human level, like figure out why they're angry, what's happening, and really kind of get into the psychological bits and pieces of it a little bit within reason, and diffuse the situation and really try to connect as human beings again, and just kind of talk about what it's not working. How can we help you move on to some place where they will be successful, and they're still putting the employee first and being very humane about going to the process. But at the same time, it's a business. You have to protect yourself, and you have to demonstrate that you are 100% willing, able, and prepared to go to the line if that's what you exactly have to do, but you don't want to do it. You'd rather do it amicably from the beginning. So that's just a quick point there. I'm thinking about, is there anything else that you're thinking about from your side, Nathan, from a legal component that came up over the hour?
I think we've covered it. If I think of something, I'll raise it, but I think we've covered quite a bit of ground.
Exactly. A lot of really important components there, I guess. And then I think what we can do is we can just open it up to questions if anybody has any points or comments to add to the discussion. I think that we covered everything there. I guess why don't we just end with the top 5 pro tips from your perspective? So if you're at 5 of the most important things you can do to protect yourself as a new entity in the United States, or a new company, a startup of whatever kind, what would it be?
Are you asking me, Zach?
Yep, sure am.
It's related to employment only?
Yep. Well, actually, we can get a 2 for, how about 2 for employment and 3 for something else? See, whatever you feel is the most important thing.
Well, harkening back to what I started with, forming a U.S. subsidiary, and it ties in with employment because that's the entity that will employ the people that you find here in the U.S. that you want to engage. But more globally, it will act as a separation of legal liability from one country to the next. So I guess number 1 for me would be forming a U.S. subsidiary. Number 2, engaging an attorney early as possible. Number 3, having a written contract in place with whomever you engage. And number 4, determining what the right contract is, employment versus independent contractor. So that'd be 4 for me. If you want to throw in a fifth one, Zach, or have your own list.
Yeah, absolutely. I'll go down through my 5. So the top part of it is being able to, because what we're talking about is when the relationship is done and you're getting ready to kind of wrap things up and make sure your ducks in a row so that things can't come back and bite you later on. And I'm just a big proponent of and this gets back to so I'll kind of back it up a little bit to the hiring and being able to and retaining employees. And is when you have the right people trying to figure out what it is that they're intrinsically motivated into, what if they're having a bad day or a bad couple of days, being able to sit down and figure out why that is, and being able to watch how people are interacting with other employees and noticing kind of some strife and being able to be a coach, to be a within reason psychologists, depending on what people's comfort levels are, just being able to gauge those boundaries as well, but still being able to talk in a reasonable way so you can kind of solve some of those problems. And also it allows people to, gives them a sense that you're there to help them as much as possible, but at the same time making it clear along the way that you're also there to protect the company, to make sure that the company is here to live another day so that the company will continue to be profitable, to keep everybody else having a job at the same time and that kind of thing. So just so that everybody's roles are clear, but still being able to help people out along the way. And when you're dealing with international companies, you've got language issues and cultural issues where people will come in where they've grown up and lived in a space that's totally different than here. They've had totally different ways of looking at the world, totally different ways of behaving with people. And sometimes things don't quite jive very well. And unfortunately with Americans in general, the cultural sensitivity is a little bit lower, for better or for worse. It just is what it is. Americans don't really have to travel a whole lot. And if they do, they're going to be speaking English a lot of the time. And so therefore, the foreign company has to be a little bit more flexible with that in that regard. But when I'm hiring people, it's not so much the language. If I can find somebody with language and cultural sensitivity, that's awesome. If I can have that. However, if that's not available because they're looking for a certain skill set, whatever it is you're hiring for, number one thing that I look for is the ability to learn, and curiosity and openness to get past a lot of that, to sit down with people and to learn where they're coming from, and then get past the cultural bits and pieces so they can move on and become bigger and better professionals. And that just takes a certain type of managerial experience, I guess. And so that's a big part of what I found that solves a lot of the problems and keeps things going from my perspective. And then using your tools. When you get to a point where you need help on the legal side, talking with the Nathans of the world and the accounting side, and then management side, and just making sure that you know where to reach out to when things do get a little bit difficult. And hopefully you can get all your ducks in a row before things get difficult, so you'll just be ready when you get there.
Zach, I think Tracy has a question that submitted. Thanks, Tracy. Yep. She submitted by way of message. So I think this one's for me. So how long should a company allow for the process of setting up a U.S. subsidiary? It doesn't take long, is what I'll say. The timeline is different from state to state. You need to figure out in what state that the company wants to incorporate. And let's say, for example, Delaware, which is probably the most famous state for incorporation for a variety of reasons, which I won't get into. If my client comes and engages us to incorporate a U.S. subsidiary in Delaware, from the time we're engaged, we could have it. We could have a subsidiary incorporated there within 24 to 48 hours. If it's filed on an expedited basis, which is an option in Delaware and many other states for an additional, filing fee, they'll expedite it. If you do not expedite it, then it generally takes 2 to 3 or 4 weeks, depending on the state, to get a company incorporated. And once you get incorporated, then you'll need a EIN, employer identification number, which is also serves as your tax ID for tax purposes. But so if you have someone within the company that has a U.S. Social Security number, you can get the EIN number, immediately, essentially within hours of submitting the information to the IRS. If you do not have a U.S. citizen with a Social Security number, then it's a little bit longer, but it's like 3 to 4 weeks before you get your EIN. You need your EIN to open a bank account for the U.S. subsidiary. So that's kind of the process for setting up a U.S. subsidiary from start to finish.
And here's a quick question: is when is it more beneficial to set up the company in the state where you're thinking about having the office, and when does it make more sense to do it in Delaware?
Well, I think the place to start there is to say that wherever you incorporate, you exist on paper only, and you can make it otherwise by opening up an office there if you want, but you do not have to. So, for example, if you incorporate in Delaware, you exist in that state on paper only. But you can have your physical office, you can have your employees in any other state. I think the best way to answer the second part of that question is by just kind of briefly touching on why companies go to Delaware. If none of these pertain to your company, then incorporate wherever you want. But Delaware used to be popular for tax reasons. My video is a little slow. Can you hear me? Okay.
Yep.
Okay. It used to be tax advantages that drove companies to Delaware. Now all the states, are very similar. So it's not really tax advantages, but because so many companies flocked to Delaware to incorporate, that state really became kind of a haven for, not necessarily tax haven, but a legal haven for these companies, because there was a very well thought out corporate code that governs your company, very knowledgeable judiciary, because courts handle these commercial disputes all the time. And the Secretary of State of Delaware is very efficient in terms of filings that you have to make on an annual basis for these subsidiaries. So for all those reasons, and also, I don't want to leave out, if there's going to be an investor or some company that comes in and buys your company at some point, those investors or that company that's acquiring your company, they're familiar with Delaware law. They want Delaware law. They don't want to deal with some company that's incorporated in Wyoming or Nevada or Alabama or whatever, because they're not familiar with that law. They don't know any companies that are incorporated there. They've never dealt with it before. So they would much prefer that there be an Inc., not an LLC, and they'd prefer it to be incorporated in Delaware. If none of those apply to you, if you don't care about those, then go wherever you want. Doesn't matter otherwise.
Thank you both. And Zach, you anticipated one of my questions there, but do they need, whether you're talking about where they're going to incorporate, set up their subsidiary, or filing to do business in a certain state, so that they can hire somebody, do they have to have a physical address to list on those applications?
So in any state in which a company is incorporated, they must by law have a registered agent address. The registered agent address is the address for service of process of legal papers, not your regular mail or whatever, but notices from the Secretary of State of Delaware, for example. It's the place where a company would be served if a lawsuit was filed against the company, things like that. So it has to have a registered agent address. And then a lot of our clients have business addresses, either at a physical office that they open, or my office offers a kind of mail forwarding service where they can list our office as their address, and we will forward them their mail, or they can get a virtual office, shared office space, and they can use that address as their business address in the United States. So one or the other of those addresses can be used on whatever forms you need.
Okay, thanks.
Yeah, and another quick point about the Delaware incorporation, but also the difference between an LLC and a C Corp, is that, again, getting back to if for whatever reason that part of the company is going to be spun off or sold, a C corp is much easier to buy and sell because it's based on shares. And whereas LLCs can be a little bit more complicated because they're connected to an individual or set of individuals. And maybe talk super briefly about that. I've got about 3 more minutes until everybody's done with the program today. But
yeah, I mean, LLCs are popular among really small companies, mom and pop companies, so to speak, because it doesn't take upkeep, right? With a C corp, with an Inc., you need to maintain corporate formalities. You need to have annual meeting minutes and the like. And there are people who need to serve as officers, president, treasurer, secretary. Whereas an LLC, the owners, are just called members, and there's really no shares that are issued to shareholders like in an Inc. It's just, the members own the company. Sometimes it's designated in what percentages, sometimes it's not. And it's just a lot less clear and formal in an LLC oftentimes. So that's not always the case. But a lot of times that's the case versus an Inc. And what I will also say very briefly is foreign companies often like Incs because it doesn't subject, generally speaking, their foreign parent company to taxes in the US, because the taxes stop at the corporate level, and the US subsidiary, the Inc., is taxed in the US on its income. Whereas an LLC is a disregarded entity for tax purposes. I'm not a tax attorney, but this is very generally speaking. It's a disregarded entity for tax purposes. So all the revenue stream for the LLC would flow through to the parent company and subject the parent company to taxes in the US. So that's also a difference between the two.
That's huge. That's a big deal. And this has been great. So we're right at about 12:59. And unless anybody else has any other questions, I'll just open it up real quick. And otherwise, once again, thank you, Nathan, and everybody else that came to the program today. Once again, this has been a program of the International Trade Association of Greater Chicago. And if you have any questions, feel free to reach out to myself or Nathan. And we thank you, everybody, for stopping by and wish you a wonderful afternoon.
Thanks, everybody.
Take care, everybody.
Thanks, Zach. Thanks, Nate.
Bye.